What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And this legal submission is the big one because we have some news in the UFC Antitrust Lawsuit. On Wednesday, August 9th, Judge Richard Boulware finally issued his class certification ruling, and he found in favor of the plaintiffs as described in the Bout Class. The individuals that competed in the UFC from December 16, 2010 to June 30th, 2017. He found in favor of them in allowing them to litigate this lawsuit against the UFC as a class of as a class of plaintiffs instead of individuals. So that was the big issue. We knew about that. That was going to come down the pike by Richard Boulware. It was just a matter of time as to when he would issue the opinion. So finally, we get the opinion. And I know this has been diced up and examined overall by multiple people, but let's just kind of get down to the nuts and bolts of the decision and what will happen next. And let's start with the last thing first. What will happen next? The UFC has already issued the statement that it will file an appeal. The official appeal has not occurred yet. It's 12 days from the date of it's 14 days. 14 days from the date of which the order was filed. So August 9th, 12 days from 14 days from August 9th, 2 weeks. We will see an appeal from the UFC. That goes to the Ninth Circuit Court of Appeals. We don't know if this is going to be a full set of judges on the Ninth Circuit or a three-judge panel. Usually they go with a three-judge panel. Okay, so that's what happens with that. As far as timeline goes, it's going to be a long one with federal appeals. They go on a schedule, but you shouldn't be expecting anything going on until perhaps sometime next year. With that being said, let's look at the actual opinion. And so several things were raised up in the opinion from Judge Richard Boulware. As I had mentioned, we knew that he was going to go ahead and grant this class cert for the Bout class of individuals. He did deny the identity class of individuals, which were the people that were suing based upon their name, image, and likeness, their intellectual property rights. Judge Boulware thought that those had to be addressed individually. Now, one of the big issues in the class certification stage was the expert testimony of both plaintiffs and defendants, notably the expert analysis of Dr. Hal Singer, who examined extensively at the hearings that happened, I believe, in 2019 regarding the UFC and how fighters were impacted by the purported alleged scheme of the UFC in suppressing wages through anti-competitive measures. Judge Boulware allowed it to expert testimony. The UFC, of course, opposed it. We had a wage share discussion that has gone on and on. The UFC argued that Dr. Singer's analysis and a multivariate regression analysis was novel and shouldn't be used and isn't particularly used for this type of analysis for the UFC MMA industry. Not the UFC industry, but the MMA industry. You get the point. Judge Boulware said no. Basically, that econometricians who study monopolies and monopsonies can utilize these types of regression theories, and therefore allow the analysis and expert testimony to be allowed to be utilized and evaluated in terms of whether or not the plaintiffs in this lawsuit could show the anti-competitive measures of the UFC. So that goes in, and then as you could probably infer from what the UFC has argued, that this will be a huge bone of contention on the particular appeal, whether or not Dr. Singer's study and analysis can come in. So we go now to one of the big issues as to why the opinion took so long, and this is with regards to the issues regarding class action. So there's 4 elements to class action that plaintiffs must prove for it to be certified by a judge. So there is numerosity, typicality, commonality, and adequacy. So those are the 4 things, and I just rattled them off because that's how all the attorneys study for these elements when they study for the bar. Numerosity deals with the number of individuals in a particular class. So here, let's just assume that was a go. Plaintiffs had argued that there were there were hundreds of fighters that were affected by this particular lawsuit, and therefore there's a great depth of individuals here that can combine together for this lawsuit. So there's that. There's the adequacy component, which deals with whether or not the attorneys that are bringing forth this suit are equipped to deal with this particular matter and can work on this wide scale of litigation, which will include reaching out to potential class individuals, having them as a class, and as well as coordinating that type of litigation with so many participants. So those 2, numerosity and adequacy, can really just be included and okayed and checkmarked. But the other one that comes to mind is typicality, which is the typical, whether other members have the same or similar injury, whether the action is based on conduct which is not unique to the named plaintiffs, and whether other class members have been injured by the same course of conduct. So the UFC challenged the typicality on the grounds that fighters with greater popularity and prominence had negotiating levers that the named plaintiffs did not. They also argued that the plaintiff's experts model, 14 fighters with the most bargaining power, actually benefited from the alleged scheme rather than experience any adverse impact from it. So we'll talk about that in a sec. And they also had they also talked about this with respect to the commonality argument. So the judge actually denied these typicality arguments by the UFC, just stating then that the claims need only be reasonably coextensive with absent class members, not substantially identical. So basically, same, not similar. That's what he's trying to say here. For them to meet the threshold, the typicality of the potential claims or defenses, when court determines there is a same or similar injury, it doesn't have to be identical. It has to be just in a general realm, reasonably coextensive, as the court puts it, citing a case, that they just merely have to be within the same ballpark of the alleged injuries. It doesn't have to be the same dollar amount. Doesn't have to be the same scheme that they were injured in. It just has to be within the same realm there. The commonality issue is the issue that the court held on to because of a case by the name of Olean, which was ahead of the Zuffa case. So Olean, we've gone over before, and it deals with it deals with tuna manufacturers and a potential antitrust claim within that particular industry. We'll call it the tuna case for the sake of this discussion. And basically, the central issue in Olean was whether or not plaintiff's evidence proved that a common question is capable of class-wide resolution, and that there is no per se rule preventing certification of a class that includes more than a de minimis number or injured class members. Now, remember we just talked about the UFC stating that the model asserted by the plaintiffs to show harm actually included some plaintiffs that benefited from the actual scheme. And just to throw out a name, Conor McGregor was one of those who was put into this analysis, and he actually benefited from the scheme rather than was disproportionately affected by the scheme. So the UFC is saying, hey, you can't have a class with a guy like Conor McGregor because there's no harm, no damages to show because he actually benefited. So that is the crux of the issue. And the Olean case, which went up to the Ninth Circuit Court of Appeals and was denied by the Supreme Court as far as an appeal, the Olean case confirmed that class action suits need only have a common question capable of class-wide resolution. So it addresses the de minimis issue regarding class members that may not be injured. So the push-pull here is the UFC is arguing that you can't have a class action lawsuit where have people in a class that aren't injured because they shouldn't have standing, because standing being the rationale for you to bring a case. So you have to show injury and damages. That's mainly the big two things you have to show: injury and damages. And if you have no injury, you have no damages, and therefore you shouldn't have the assertion that you could bring a lawsuit. So that's the UFC's issue, the argument. That's their big argument. And Judge Boulware, citing Olean, basically said you just have to have a capable class-wide resolution to a common question. So it goes back to the de minimis argument, meaning that even though they have a class certified to file a lawsuit, a small class of people that can be inserted into that class that could fit the particular definitions of the class can still be a part of that class, even though they themselves cannot show injury. So that's going to be another bone of contention on the appeal, is that, well, how can they show this? How could they bring this class action lawsuit when some of the people in the lawsuit shouldn't be there? So those are the big issues. Again, this is just one of many hurdles that will come to pass, because even if this passes muster, they still have to litigate this case. They'll probably renew its motion for summary judgment and get to that particular point. Now, this is similar to the Liv lawsuit, where Liv sued PGA for antitrust violations. As you recall, or if you follow that, they settled the case and combined the Liv and the PGA Tour. We'll talk about that later in another legal submission, but that's where we sit now. We'll probably do another one once the appeal comes out in a week's time. I'm Jason Cruz for MMA Payouts, the legal submission. Please like, subscribe, keep me in your loop. Thank you very much. Have a good day.